Good evening, friends. Welcome on this special webinar on the POSH workshop, Prevention and Prohibition of Sexual Harassment at Workplace. Very important after the enactment of the law in the year 2013. We have a great personality with us, Rashmi ma'am, Khetrapal ma'am. She is a chairperson at LCC POSH Committee Gurgaon at LCC. She is also connected with the she is a more than 16 plus year of experience in accounting and finance. Have been held the esteemed post of the chairperson of the Gurgaon branch of the NIRC of ICI during the year 9-10. Also, first lady to be elected as NIRC member of ICI in 2010-13. During the tenure NIRC member, have held various prestigious positions like NICASA chairperson, chairperson for CA members in industry, chairperson from branch coordination committee, chairperson for VAT committee, many other areas. Expertise area in the field of assessment and appeal cases for VAT, service and income tax, corporate and high net worth individual. So, improvement, repair and maintenance in the parks of Suhan's Lok conducted many public awareness programs, get together on health issues, Swachh Bharat Abhiyan, helping children from the economically weaker section by providing scholarship, arranging and uniform. Madam is also a state convener for BJP Economic Cell Haryana. Madam also an independent director is HSIIDC Haryana, and also a chairperson SHWW LAC, that is same prevention of post chairman basically. So with this introduction, would like to request Madam for keynote address for our today's webinar. Ma'am, we cannot see your camera as of now. It stop. Rashmi ma'am, can you able to hear us?
Yeah, I'm able to hear you now.
Yeah, ma'am, we cannot see you. Your camera is on pause.
Okay, let me see. No, I think. Can you see me now?
No, ma'am.
No, ma'am, no.
Okay, wait. Can you see me now?
Yes, ma'am.
Okay.
So would like to request ma'am for keynote address for our today's special webinar on POSH. Over to you, ma'am.
Okay. Thank you, Viraj. First of all, I would like to thank all of you who have taken out time, especially on a Sunday afternoon, to talk about such a sensitive topic. And a great thanks to Surbhi also. I was not expecting somebody so younger, but I'm very happy to see that young professionals like you are also coming up to take on such topics. Although when we talk about any law, and especially when we talk about laws which are made for women, especially for empowerment or for prevention of harassment of a woman, those acts are made, but they are not normally discussed.
Correct.
The intention of the lawmaker is very clear when they make the act, and even this act, which was made in 2013, but the implementation takes a lot of time, and it is on professionals like us, I would say, because we are also chartered accountants and advocates. We both walk hand in hand in ensuring that there is an awareness of this special act amongst all of us. And when I say why all of us, although I'm sure Surbhi, you will be taking them through the various stages on whom this act is applicable. So I will just give a brief note. This act, which is Prevention, Prohibition and Redressal of Sexual Harassment of Women at Workplace, was enacted in 2013, and it is applicable to everyone. Do not think it is not applicable on me. It is applicable on everyone, because each CA firm which has even one single employee or even one single article trainee, this act is applicable on them. All organizations, be it proprietorship, be it partnership, be it companies, private companies or public companies, it is applicable on all. Now it is even applicable on our domestic health that we have. So even if somebody is not doing any business, we are still having domestic help coming to our homes. So the act will become applicable there also. And especially for CAs, it will have a double purpose, because we are supposed to do audits in the organizations. In the organizations, when we talk about public and private limited companies, there is a director's report which is signed by the director and which forms integral part of our audit function. There the directors have to specifically declare whether or not this act and the regulations of the same are being implemented in their company or not. Correct. So everybody, I'm very thankful and happy to see that there are so many people who are attending this webinar. But what I want to say is it is applicable on everybody. There's not even a single person on whom this will not be applicable. And if there is somebody who says, okay, it is not applicable on me, then at least your wives, your mothers, your daughters, your sisters are going out to work. So even for that purposes, you need to know this act. So this act was specially enacted to prevent the sexual harassment that a woman was undergoing or is even now undergoing at their workplaces. Now, when we talk about sexual harassment of a woman, there are various ways of sexual harassment, and I'm sure you will be learning about them in detail. And when you will learn, you will be amazed that all these things also constitute sexual harassment. But I will just give a very small gist. Sometimes the society, we are not able to sanitize men about what will constitute an harassment for a female and what will not constitute an harassment. So when we talk about this act, although we want the women who are sexually harassed to get redressal, but for prevention and prohibition, I would request the men to come forward. Because if the men can understand what for them is normal, we have so many cases which come, and one very recent case which came to us, where the team who had there were 3-4 people against whom the case was going on, and all of them said in an office organization, saying non-veg jokes is a very normal thing. Sharing certain memes is a very normal thing. But what we do not understand, maybe what is normal for me might not be normal for another person. So for me, seeing that meme and probably laughing out could be okay, but for another fellow colleague, female colleague, she may not like them. So we cannot take it for granted that nothing like this is happening in the society. Yeah, okay, whatever we do is acceptable to all. So there is no such acceptable norm. Okay, you can do this with a woman and you cannot do this with a woman. Whatever a woman finds objectionable is objectionable. Period. There is no debate on that. Right? There is no debate that I did it because of this. Ma'am, आज आप बहुत सुंदर लग रही हो, आज आप sexy लग रही हो, या मैम चलो आज lunch करते हैं. These remarks, if unacceptable to a woman, they are unacceptable. So we have to understand from a woman's point of view what is making her uncomfortable. Because what is the aim of this act? The aim of the act is, now that we have educated our females, we have educated our sisters, we have educated our daughters, now we have to give them an equal right to do work also. We can't give them knowledge, we can't give them wings and then tell them you can't fly. So this act has become even more relevant in today's world, where there are so many females who are educating from premium colleges, premium institutes, RCA Institute. If you see so many top 20-30 positions, we have so many females who are doing it. So of course, we would want all of them to get a good ground for them to work, you know. And when we talk about this act, we're not talking about disparity amongst anything. We're not saying ki you give a special privilege to a female, or we are not saying anything like that. What we are only saying is respect her mentality also, let us say. Respect her decision, respect what she likes and what she does not like. There are numerous instances where a person gets back to us and he says, I was just saying this in apnepan mein maine aisa bol diya. So there is no apnapan if the female is not liking it, right? So you cannot get away by saying these things. At the same time, since I'm a mother of two kids, two boys, and whenever I speak on this and I come back home and they are the ones who reprimand me the most, okay, what if the females use or misuse this act? So my message for the all females who are going to work is this, that we were always a society, if we go back ages, we were always a society where women had rights, equal rights. But over the years, with the invasion of Mughals and then Britishers and all, those rights got curtailed, and it is only now that the society is slowly accepting us, our equal rights in the society. So it is on us also to see that we maintain our character. If we keep on doing frivolous complaints, although this act has penalty and prosecution for frivolous fines for frivolous complaints also, but you understand, if we do a lot of frivolous complaints, what will happen, that the management will start deciding not to keep females. So the whole purpose of this will come falling on our feet. We want a safe environment for a female, but there has to be a working environment first. If managements start deciding not to hire females because of this malicious complaints that come, then it can be a very bad situation for us in the future. So then think of all those people who have worked so hard for our independence, for our education, for we being given equal rights. Everything will be defeated only because of our short-sightedness or a temporary momentary anger that you have at workplace. Also understand that there is difference between a workplace harassment and sexual harassment. Each workplace harassment cannot be termed as sexual harassment, right? So since I am only to speak as a keynote speaker, and we have Surbhi also, and I'm sure she's prepared a very nice presentation for all of you to see, and I can see a very good picture which she has shared, and which is a classic example of sexual harassment, which at times people don't even realize. And this kind of harassment is not limited to young females. We have so many cases where female above 50 have also come to us with such cases. So this is something which is very much real, affecting us every day in our life. And I'm sure there is some statistics which says that so many women out of 10 are being sexually abused or sexually harassed. And all these things gained momentum after the Me Too movement. You know, everybody remembers वो Me Too movement होने लगा, और उसके बाद इसके बारे में awareness और होने लगी, which is a good thing. So what we have to do is ensure that the work environment is absolutely safe for any female to work. All measures to prohibit sexual harassment are there at the workplace, and at the same time, if any female is feeling sexually harassed, so redressal to her is given to her at the immediate time, and a time period of 90 days is prescribed for the whole proceedings. So that is adhered to, and the female is not thrown out of the company till the pendency of the case. This is very important, because there are many cases which come where the company will say कि हमने दोनों को निकाल दिया, हमने उस लड़के को भी निकाल दिया, हमने इस लड़की को भी निकाल दिया. So no, this is not acceptable. You cannot, the company wash hands by saying कि ठीक है, हमने तो जी लड़की ने कंप्लेंट करी थी अपने मैनेजर के अगेंस्ट, हमने तो दोनों को निकाल दिया. This is not acceptable, right? So I will now give it to Viraj. So take it forward, and I am once again thanking you all. And I wish कि आज इस program के बाद, when you go back home, please discuss it in your home also with your wives, with your sisters, with your mothers, with your daughters. Do not shy away from discussing this topic just because it is a sexual harassment word that is we are doing. Do not shy away from sharing this topic with your females at home, even with males. I said because it is the males which needs to be sanitized. Okay, what is acceptable and what is not acceptable. With that, I wish you a very best. Thank you.
Thank you so much, ma'am. Would like to inform all of you that Rashmi ma'am has accepted our invitation immediately. I called at around 2 or 2:30 or even late, I think, and ma'am has immediately accepted that. Yeah, surely I will come for this topic as a chairperson also. So, ma'am, thank you so much, ma'am, for that acceptance and giving us all about the your this topic and opportunity for the CA and CS in the form of audit report and mentioning in the reporting requirement. So with this, would like to now request our friend CA CS Nishi Oswal to introduce Advocate Surbhi Oswal. Over to you, Nishi. Nishi, you have to unmute yourself.
Sorry,
yeah,
am I audible?
Yes, yes.
Advocate Surbhi Oswal has completed her Masters in Law and specializes in the field of civil law, real estate, drafting, conveyancing, litigation, arbitration, and family matters. She appears before civil courts and high courts. She also works in the field of POSH, that is Prevention of Sexual Harassment at Workplace, and conducts seminars and assists companies as an internal committee external member under POSH. She is an external member of various internal complaint committees of many organizations. She handles the entire POSH department of various companies. She is qualified as an independent women director, certified by the Indian Institute of Corporate Affairs. Apart from that, she has pursued several certified courses. She loves imparting knowledge to the people around her and works towards the upliftment of women. Over to you, Surbhi.
Thank you, Nishi, for this introduction, as well as ma'am, Khetrapal ma'am. You have given a wonderful practical experience, which I may say, for this overall view of POSH. Thank you for the same. And in fact, it was really insightful. Taking ahead to what you said, in the entire, also thank you, Virag, for this entire presentation that you have kept over here right now. Thank you. Taking it ahead now to tell you all, now I know that not everyone over here is really aware of what POSH is. Probably you have heard it for the first time, or probably you have heard about it, but you don't know about it. So for those, I think those people, this kind of a webinar is going to be really helpful, as well as for the other people who actually need to know the procedures, or probably who are members of the internal committee and want to know how to take it forward. I think this webinar might be helpful for you all also. With this, I take you through what am I going to tell you about in this entire presentation. One is that from where does this, what is the base of the Act? The base is nothing but the Constitution of India, as well as the preamble to the Constitution, and the preamble of the Act will give you the entire overview of this Prevention of Sexual Harassment of Women at Workplace, Act 2013. Then from where does this originate, or what led to this enactment of this Act, is something which is a very famous case law of Viragshah versus State of Rajasthan, which I will be discussing here. Then who all are employees and who all are covered by this Act? Who is an aggrieved woman? What is the meaning of an aggrieved woman? And then what is a workplace? So this Act is confided, as ma'am said, to a workplace. So what exactly falls within the category of a workplace is what I'm going to discuss. Then what actually constitutes sexual harassment and not what? Then what is the role of the employers? As the Act says that it has to prevent and prohibit such acts of sexual harassment. So what are the roles of the employers? Then, as the most important thing of the act is to set up an internal complaints committee. So what all is required for that, how is it set up, and everything about the internal complaint committee I am going to share with you. Then comes the complaint, who can file the complaint, where can it be filed, what is the procedure, what are the guidelines which are involved as far as the complaint is concerned, that I will be discussing. What are the responsibilities of the committee, what are the powers, what are the timelines within which the complaint should be made, or what should be done as far as the timelines is concerned under POSH. Then what is the ambit of confidentiality that has to be maintained, what happens if a false and a malicious complaint is filed, what are the recent judgments, what is the outlook of the court, whether the Supreme Court or the various high courts, which I will be discussing with you, about 7 to 8 judgments, and the recent orders that have come up under the act, which actually prescribe the mandatory forms which have to be filled in by various people, which includes CAs also. So what all has to be done, which I will be discussing and taking you forward with that. So with this, I start with the preamble. Now, the preamble of the act itself, which is the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act, it itself says, whereas sexual harassment results in the violation of the fundamental rights of a woman to equality. So this itself says that when there is a sexual harassment which takes place, it is nothing else but the violation of her fundamental rights. Fundamental rights are written in the Constitution of India. Now, if I may take you that which of her fundamental rights are violated, then I have mentioned over here, it is Article 14, which states right to equality. So that gets violated. Article 15, which says no discrimination should take place on the basis of sex, and Article 21 of the Constitution, which says right to live with dignity and it includes to live with respect at workplace. So all these three, 14, 15 and 21, they all get violated when it comes to a woman being sexually harassed at workplace. Along with it, there is also Article 19(1)(g) of the Indian Constitution, which is also a fundamental right, which states that right, which gives a woman or any person the right to practice or carry on any occupation, trade and business free from any kind of harassment. So all these things are violated when it comes to violation, when it comes to a woman being sexually harassed at workplace. Now, this is also reinforced by the UN Convention on the Elimination of all forms of discrimination against women, and then subsequently that also is ratified by India, and then in the year 2013 it came in the form of the Prevention of Sexual Harassment at Workplace Act 2013. So keeping in mind the preamble, I will take you through what actually happened in the year 1997 as to why this came in the forefront, and why in the year 2013, though I may say that it is really late, but nevertheless, why in the year 2013 this act came into picture. Now, Viragshah judgment is something like one Mrs. Bhanvari Devi. She was employed by the state of Rajasthan. Now, what her work was, in her work that state of Rajasthan had employed her was for, she had to prevent all the child marriages. Now, in doing her work, there was one marriage of a 1-year-old that she prevented in the state of Rajasthan, which was not liked by the community, by the men of that particular community. So she went and complained to the state government, but the state government did not listen to her. And then post that, she was raped by those women. It was a heinous crime. And then Bhanvari Devi, later on, Viragshah is a group of that NGO of state of Rajasthan. They themselves, under Article 32 of the Indian Constitution, they took up this case before the Supreme Court of India, and a judgment was passed in the case of Viragshah versus state of Rajasthan. Mind you, before this judgment, there was no definition of the term sexual harassment. So by this judgment, what happened is, by this judgment, the Supreme Court gave forth certain guidelines, because of which there came a fixed definition of the term sexual harassment. What happened is the accountability changed from individuals, then it went to institutions. So now the state government, the person who employs, has to be responsible for the person who is actually sexually harassed. So over here, through this judgment, the accountability shifted from individuals to institutions. Then the guidelines also gave that you have to prevent these acts from getting committed. Then there were the Supreme Court also came up with innovative redress mechanisms. And finally, as I said, though it was late, but in the year 2013, India enacted the law, the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013, which covers the whole of India. Keeping this in mind, I will then take you through, as I said, employees. So today, who all come under the ambit of employee? All employees of any company are governed by this act, which includes trainees, management trainees, interns, support staff, full-time employees, both permanent and on probation, temporary employees, third parties, independent contractors, or outsiders who are appointed at any office. All these people, so if there are more CAs over here, all the interns or probably CAs who work in a company or probably in a private firm, all these come under the ambit of employees. Now, next is an aggrieved woman. Now, who is an aggrieved woman, which the Act classifies as any woman who visits a workplace or probably for any work or is a student, and she is a regular, temporary, ad hoc, or a daily wager. She works for remuneration, she works voluntary or otherwise. She's either employed directly or through an agent. She's a contract worker, probationer, trainee. Any kind of woman who's also an employee comes under the definition of an aggrieved woman. Now, many people of you might ask the question, why is it so gender specific? Well, if in the coming slides also, I have written my recommendation because of the changing times now. The word aggrieved woman should definitely be replaced with an aggrieved individual. Now, it does not mean, I know many people might have this question, can a man not be aggrieved? Can a man not be sexually harassed, or probably any other gender, which I may not be gender specific? So, because of the changing times, I feel that there should be an amendment to include the word aggrieved individual and not an aggrieved woman. But till date, the law states that only a woman can come forth under this act to file a complaint if she is sexually harassed. Now, what is a workplace? So as you can see in this, it's any government organization, NGO, nursing homes, corporations, companies, house, financial institution, farms, hospitals, sports facilities, service providers, cooperative societies, any kind of a place which actually employs people, that is called a workplace. A dwelling house is also a workplace, as Man has already mentioned. Now, what is workplace sexual harassment? As I said, that this term was coined, sexual harassment, for the first time it was defined in Viragshah versus state of Rajasthan in the year 1997. And that exact definition is coined in the Act of 2013. It means it includes any one or more of the following unwelcome acts or behavior, whether directly or by implication, namely physical contact or advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. So all these come under the ambit of sexual harassment. As ma'am said, an act, now it does not mean that there is a straitjacket formula to define the term sexual harassment. An act can be demeaning or it can be unwelcome for a female, but a male may state that no, it is okay. So what if something which is unwelcome for a female, now that is something which the people look at it, the committee should look at it as sexual harassment. So all this is, as I said, it is not an exclusive definition, it includes all these acts. If there are more than that also which actually come under the ambit of sexual harassment, then that will also constitute as sexual harassment. Now, some examples of unwelcome behavior which are, now this also is not exclusive, it is inclusive: verbal conduct, slurs, unwanted sexual advances, use of threatening or intimidating language, the physical conduct of the person, sexually suggestive or offensively touching another's body, then the display of explicit posters, photography, drawing, gestures, sending or showing inappropriate text messages with sexual objects, displaying sexist or other offensive pictures, posters, MMS, SMS, WhatsApp, emails, any kind. Now with the changing times of work from home, let me tell you, even through emails also there have been many cases of sexual harassment. In fact, there are many cases that I've been personally dealing with under POSH because of this change in policy of work from home. So in fact, the number of cases have actually risen from what they were earlier with the change of concept of work from home. So all this, as I said, now one act may probably not constitute, but series of acts, or probably one slur over here may not constitute sexual harassment, but the entire committee, which I will be dealing with later, has to see the entire scheme of events and then come to a conclusion that yes, there is sexual harassment, or no, there is no sexual harassment. So some of these acts may, in a given particular scenario, may obviously constitute sexual harassment. Now, so what is the role of an employer? Employer is what? Any person who's a head of a workplace, who manages a workplace, who takes care of everyone in that particular workplace. So as the head of that organization, what is his role? So now the POSH law, which is Prevention of Sexual Harassment of Women at Workplace, it mandates every employer, he has to constitute or nominate members to an ICC. ICC is an internal complaint committee. He has to, that it is a compulsion under law. It is not that it is discretionary to his powers, or when he cannot say that, okay, let a case come up, then I will constitute an ICC. He should not do it. At very moment, if you have not formed an ICC for your organization, then I may please request you to do that, because there is a mandate under law. Not doing so, there is a prescribed penalty for the first time of 50,000, and then later, if that is not followed also, then your licenses of the company or the organization may be revoked. So the employer has to nominate members to the ICC. Also, his role is to provide a safe working environment, which shall include safety from persons coming to the workplace, display the penal consequences of workplace sexual harassment and the order constituting the internal committee at any conspicuous place at the workplace. This all is required as per law. Then he has to create a deterrent to prevent these acts. His act is not only to constitute the IC, but to prevent also such acts. So one of the acts that he has to do is, he has to create a deterrent to prevent these acts from happening. He has to have, he or the organization should have a zero tolerance policy towards sexual harassment. Along with it, he has to hold time and again orientation programs under the POSH Act, so that everyone in the company or the organization is aware of such constitution of such body, as well as the act. Then he has to publish the POSH law related policies over the company internet, or service rules, which shall include the contact details and the names of the ICC members. I shall be dealing with the constitution of ICC in the coming slides. Then he has to carry out capacity building and skills development programs for the IC members. He has to organize workshops, regular programs for the employees and the committee. He has to be extremely sensitive. He also has to circulate guidelines under the POSH Act. He has to hold awareness programs. So all this is what the law mandates that the employer should do. Now, this will help to prevent the crimes or the sexual harassment against women in such cases. So he has to play his role. So he could probably, by doing all these acts, play his role so that he could prevent a crime from happening. Now, as I said, what is the Internal Complaint Committee, which is the most important thing in this act? Every employer is obliged to constitute, to hear and redress the grievances of sexual harassment through a written order. Failure to constitute an IC leads to imposition of fine under the Act upon the employer. Now, the composition, the most important part, that the ICC will be composed of the following persons or the members. A chairperson, she has to be a senior level woman employee who is the presiding officer, who will be nominated by the employer. Now, my recommendation over here is that there should be 2 officers in the ICC so as to ensure easy and timely completion of inquiry. So here officers, I mean a chairperson. There should be 2, so that just in case a chairperson is not there, then the other chairperson can take over. So every time there have to be 3 minimum people who are there to conduct an inquiry, out of which one has to be the chairman or the chairperson. If the chairperson is not there, then the inquiry cannot be conducted on that particular date. So for that reason, my personal recommendation is that there should be 2 officers, but such thing is not there in the Act. Along with the chairperson, there have to be members, minimum 3. They should be trained under the POSH Act, should be preferably the members of the company and sensitive to issues, good credibility and technical competence. That ICC should be autonomous, and there should be a separate space for a meeting of the ICC and the records. Now, out of those 3 people, as I said, not less than 2 members from amongst the employees of that particular company or organization, preferably committed to the cause of women, associated with an NGO, and experience in social work, legal knowledge. So that makes it 3. 1 external member has to be there in every committee, so that I can say is that the body can be autonomous. All right, that external member should be experienced in social work, familiar with the issues of sexual harassment. It can be anyone, like an advocate or any other CA or any person who is obviously autonomous because that person is an external member and is experienced in that particular field. What the next compulsion or the next point is whether a man can be a member of the IC. So what the law states is that not less than 1/2 of the total members shall be women. A minimum of 3 members, including the presiding officer, have to be present while conducting the inquiry, as I have already mentioned. Now, where the office or the administrative units of a workplace are located in different spaces, divisions or subdivision, an ICC has to be set up for each and every administrative unit or office. If you have, suppose, branch offices, or you have offices in units in probably Delhi, Maharashtra, or anywhere in different states, then every state also, or every office, should have a separate ICC. Now, one of the recommendations which I personally have, looking at the cases, is that there should be a schedule of ineligible persons to be members of the ICC for one particular case or a particular case, if the member fits into the category of ineligible relationships. So what happens is if there are 4 members of the ICC and I suppose bring up any complaint, and I make an application that Mr. XYZ, who is a member of the ICC, should not be there to conduct my inquiry because he happens to fall in the category of ineligible relationships, so that his decision is not favoring me or probably is not against me also. But the Act does not postulate this, and with that keeping in mind, the constitution of ICC, as I said, that there has to be 1 presiding officer who has to be a senior most member of that organization, a female senior most member, 2 other members from the organization who know about the female such familiar with such kind of issues or have knowledge with these kind of issues, and then 1 external member also should constitute an ICC, so that the body is autonomous. Now, what you should remember while this POSH Act, what it actually tells you to do is to speak out. Now, if a female thinks that a particular behavior is not welcome or she does not like it, then she has to speak out and clearly tell the person that your behavior is unwelcome and I do not appreciate it. What she should do now, if she comes to know that something is wrong, she should keep a record of all the instances, the date, time, location, the possible witnesses, what happened, what was her response, what was his response. She should keep a note of everything. If she gets the slightest idea of something is going wrong, she has to report immediately. She should write a complaint to the Internal Complaints Committee. It is mandatory for every organization. Now, what I did not mention is every organization who has 10 or more members have to constitute an IC. So the mandate is 10 members or more. And if that is there, then the employer has to nominate members and to make an ICC, Internal Complaints Committee, for that organization. It is mandatory. There is nothing like, as I said, wo jab case aayega tabhi dekhenge, then we will constitute and form an ICC. That is not allowed. then the complaint should be made within a period of 3 months from the date of the last incident that has happened. This is going to be covered in the timeline. Now, reporting of incidents of harassment is important, sexual harassment obviously, because it is necessary to stop the unfair and unethical treatment. Then it could get worse if it is left untouched. It is everyone's responsibility to ensure a safe and harassment-free work environment. Now, guidelines, as I said, your ICC is formed. After the ICC, if there is a complaint which needs to be filed, firstly, or probably if there is a sexual harassment case, then who can file the complaint? Obviously, the aggrieved person, who's none other than that aggrieved woman. Any third person on behalf of the aggrieved person or the witness. If the aggrieved person has expired, then definitely her family members, her heirs, can file a complaint before the ICC. Where, as I said, it can be filed before the Internal Complaints Committee or to the manager or HR representative. But here, now, if it is forwarded to the HR representative, then obviously the HR representative will transfer it to the ICC. But since now I'm making you aware, or probably you could help the other people or the aggrieved person also, then she should file it to the Internal Complaints Committee. If there's a specific case in which you all are scared to file or something, then definitely I will be able to help you out. You can mail it to me and we can have a word over it. Then what is the procedure? A complaint. Now, well-drafted, I do not mean that it has to be very flowery or anything. A well-drafted complaint means a complaint which has all the points which you need to put. So you can definitely go to your advocate or to any person to draft your complaint. So a well-drafted complaint for sexual harassment must be filed with supporting documents as per the regulations to the ICC. Now, with details, the names, the addresses, and all kinds of reliefs, and the incidences actually which have happened, with the name of the witnesses also, with all the possible details that you can give, it should be filed with the ICC. Now, the law mandates that you have to give 6 copies of the complaint along with the supporting documents of the witnesses. Then you have to send one of the copies received from the ICC, has to send such copy to the respondent. Now, aggrieved person becomes the complainant. The woman who has filed the case becomes the complainant. Respondent is the person against whom the case is filed, the complaint is filed, or who has allegedly committed the act of sexual harassment. So that person becomes the respondent. So the minute I file it, the ICC has to give a copy or send a copy to the respondent within 7 days of the ICC receiving the complaint, and the respondent has to file a reply to the complaint within 10 working days. So these are the mandates which are given under the law. What are the guidelines as far as the complaint is concerned? What should the complaint contain? As I said, the name, the date, the timings, the locations, the witnesses, names, details, addresses of the witnesses, the relations of the parties, whether the employee, what was the post of the person, then all the proofs, all the names of the witnesses. Now, if probably you're going to a movie, then the movie ticket or any kind of proof that you can attach, all this has to be there in your complaint. Don't make it half-hearted or something which do not have the essential details. No, if there is an email which is sent, then a photocopy of the email or screenshot of the messages, WhatsApp chat, whatever can be there, ensure that all your proof is attached, annexed to the complaint, and it is well drafted. All right. Again, as I said, well drafted does not mean flowery language. It means the truth, but everything. Now, what can an employee, a worker, expect, or probably the aggrieved woman, or probably even the respondent? Now, if I may say, not all cases of sexual harassment that a woman says that sexual harassment has taken place against her does not mean that it is true. Or the ICC does not have to look at the respondent with tainted eyes. Okay, he has committed the offense just because the ICC has received a complaint. No. Now the ICC has to be autonomous, not only for the female but also for the respondent. It cannot see, as I said, the respondent with tainted eyes. Okay, because we received a complaint, he is a harasser. He has sexually harassed that female. I'm sorry, that should not be done. For the respondent also, as well as for the complainant, the ICC should be trained. It should be skilled, autonomous committee. It should give all the support to both the persons. Unless and until the ICC comes to the conclusion that yes, he has committed the offense, the ICC cannot look at the person as an offender or as a harasser. It has to give full assistance and full justice to the parties concerned. Then, what are the rights of the complainant and the respondent? When a copy of the complaint is filed or the statement is filed, it is given to both the parties. Confidentiality is going to be maintained by the ICC. They are not going to reveal, the ICC cannot, the employer, the ICC, or either the respondent or the complainant cannot reveal the identity of the parties or any particulars to any outsider. Then also there is an full inquiry procedure which the ICC has to undertake. That inquiry procedure cannot, it includes the cross-examination of the complainant as well as the respondent. So if the complainant wants, because if there are certain acts which the complainant wants to state, and her cross-examination, if she does not want it in the presence of the respondent, then the law states that it is okay, your statement can be recorded in the absence of respondent. There are no clear-cut guidelines, but through the cases and through the judgments of the courts is something which I have compiled all the material which I could to bring forth to you for this presentation. Now, after what is the procedure again to go ahead with the complaint after the ICC receives a complaint of sexual harassment? After verifying the documentation of the complaint from both the parties, an inquiry process is set up. How does the ICC conduct an inquiry? For that, the ICC conducts interviews, it conducts investigations. Now, it cannot believe that, or that whatever is given to it is 100% true. So it has to look at the other side of the story also, and has to look into both the proofs that is given. For that purpose, the committee has the same powers which is vested in a civil court under the Code of Civil Procedure, which are summoning and enforcing the attendance of any person and examining him or her on oath, requiring the discovery and the production of the documents, verifying any other matter which may be prescribed. So all these three things. Now, that is why probably in the ICC, many people, they choose to have an advocate, because all these procedures are not known to probably a layman. But what if there is no advocate also? All that all the powers which are there in any civil court, that that they can call someone if suppose they had gone out, the couple had gone out for a movie or probably somewhere to have dinner, so they can summon the owner of that hotel or any other person so that they can give their statement before the ICC. The ICC should not go at each and every place to check whether what is stated is true or no. So as the power which is given to a civil court, ICC also under the Act has such powers which it cannot obviously misuse. It can it can summon anyone or enforce the attendance of any person and examine him or her on oath. Whatever documents it wants, it can request the parties by an order to get all those documents, or to give all, for it, there is a procedure for discovery and production of documents, and by their own means, they can verify any other matter which is prescribed. So these are the guidelines under which an ICC can function. What are the key responsibilities of the ICC, the committee? One, they have to advise and assist in settling the matter through conciliation. Now, every case that comes to it, what the ICC should do is whether the case can be settled through conciliation. Conciliation is when both the parties sit and mutually, probably if they can talk it out and get a solution to the problem, then they should do it. So that is basically without the interference of a third person. So the ICC should look forward to settling the case in conciliation. Again, in conciliation, if any matter is settled through conciliation, there cannot be any monetary payment which is done by the respondent to the complainant. No monetary payment in conciliation is possible under the POSH Act. The ICC should be thoroughly prepared. It should know the law, the policy, the service rules and everything. It should know it, the ICC. Not necessary that all members, at least one member in the ICC should be thoroughly prepared with everything. Then the ICC should gather and record all the relevant information. Now, mind you, this is a very sensitive issue which pertains to sexual harassment of women at workplace. She is the aggrieved person, or probably the respondent is the aggrieved person. Such cases have to be dealt with by the ICC very carefully. All right, they have to determine what the main issue of the complaint is, whether it is made just out of anger, frustration, or whether the complaint is made just so that a revenge is taken on someone. Then all these cases have to be picked out. As I said, not all case of sexual harassment is actually sexual harassment. It can be a result of probably vengeance, or you don't know. You have to step into the shoes of both the parties. The ICC has to prepare relevant interview questions. Now, interview in legal language probably is called cross-examination. So it is the ICC which has to do everything, and it plays a very important role. And ICC cannot get away with it, because then if in appeal, the courts can look at what the ICC has done. It has to follow the procedure. Natural justice is something which obviously any governing body has to follow. Ensure that the parties are made aware of the process and the rights, the responsibilities within it. Now, the ICC also has to prepare a report with findings, recommendations, whether or not actually according to it there was sexual harassment or not. Then what all recommendations it can give to the employer. It has to give. ICC, as I said, should not be judgmental. When on the receiving of the case, it cannot look at the respondent with tainted eyes, that there is no, that the respondent has committed the act. No, not allowed. This ICC should be a fair body, should not be judgmental. Then the ICC, as mandated, has to submit an annual report to the employer about all the cases that the ICC has dealt with in that particular year. Now, what are the interim measures that the ICC can give? ICC interim measures means the case is not finally decided. If at all there is a complaint of sexual harassment, now till the case gets decided, it can take 90 days, or in some cases it can take more time also. In the meantime, if the aggrieved person wants certain kind of interim measures, then the ICC can pass such interim measures till the passing of the final order, which is the aggrieved person can be transferred to any other place or to any other office, or probably she can be told to stay at home for that particular period of time, looking at the graveness of the complaint. And in that term, when she's at home, it will not be a leave without pay. Her pay will be made to her. Then they can also transfer the respondent. They can order that for that much period the respondent be transferred to any other office. Then there can be a leave up to 3 months for the complainant, for the aggrieved woman. Then request the complaints committee restrain the respondent from reporting on her work performance or writing her confidential report, and assign her to another officer. That is what the ICC can do in the interim whilst the complaint they're handling. Then they can restrain the respondent from supervising her academic activities in case it's an educational institution. Now, whatever recommendations are given by the internal complaint committee to the employer, that employer has to implement. There is no two way for the employer, or the employer cannot give his or her recommendations. No, that is not allowed. All the recommendations which are given by the ICC have to be complied with by the employer. The employer has to implement it. Then one of the recommendations is that the ambit of the interim relief should also be extended to witnesses, because we don't know what might happen later, that the witnesses also may change their stand. So then interim relief should also be given to witnesses. Now, what is this procedure of inquiry? As the inquiry is conducted and there are hearings, there are notices for the hearings, show cause notices, which are issued to the parties, to the respondent or to the complainant. Now, if the respondent is absent for the 3 hearings despite due notice which is received by the respondent, then an ex parte order is passed against the respondent. What is an ex parte order? That only one party, which is the complainant, is present, but the respondent is not present. In legal terms, it is called an ex parte order. Next is the complainant. If the complainant who has herself filed the complaint, if she is absent for the first 3 hearings, then the proceedings are terminated. she has to remain present. He also has to remain present. All right. The committee has to give a written notice to the party concerned 15 days prior to termination or passing of an ex parte decision. The party shall not be allowed to bring in any legal practitioner or represent them in their case at any stage of the proceedings before the committee. So these are the two mandatory requirements the law states. 15 days notice has to be given if you want to terminate or pass an ex parte decision. No lawyer is allowed to be present representing any of the parties, either the respondent or the complainant. This is under the POSH Act. Now, what after receiving the complaint, after passing an inquiry, after doing an investigation, it has all the powers. Now it has to give a report, whether in their eyes, after going through all the proofs and everything, whether was there any act of sexual harassment or no. All that has to be written in the inquiry report. And then after the order is passed, after the report is passed, it has to also give its recommendations to the employer who has to implement it. If there is a case of sexual harassment, in that case, it can recommend the employer that the respondent has to either give a written apology. Now, it depends from case to case basis, looking at the grievance or looking at the kind of harassment that is involved. Either if it's a small case, probably some remarks are passed against the female and she complains, then the ICC can request the respondent to give a written apology. Or if it's a grave crime, then termination, hang of duty. There can be a demotion of the respondent, withholding of benefits and perks or promotion. They can also give a written warning, appropriate financial damages. Then they can request the respondent to undergo counseling sessions or community service, deduct salary of the respondent, which has to be paid to the aggrieved woman. Now, all these are cases in which the ICC comes to the conclusion that there has been sexual harassment as far as the girl is concerned. Now, also that because of the entire thing for the harassment, or there is some sort of a compensation or sum which is paid to the aggrieved woman, which is also probably deducted from the salary which is paid to the respondent, if the ICC comes to the conclusion that there has been a act of sexual harassment. So on what basis is that sum paid? It is calculated on the basis of the mental trauma, the pain, the suffering, emotional distress which is caused to the aggrieved woman, the loss in her career opportunity due to the incident of sexual harassment, the medical expenses which were incurred by the victim for physical and or psychiatric treatment, then the income and the financial status of the respondent, feasibility of such payment in lump sum or in installments. So the ICC can have a look over all these circumstances and also give an amount for some sort of compensation to the aggrieved woman. Now, what are the timelines which are prescribed as per the Act? You have to submit the complaint within 3 months of the last incident. Notice of the respondent, as I mentioned, has to be given within 7 days of receiving a copy of the complaint. The inquiry should be completed within 90 days. Then the report has to be submitted by the ICC to the employer within 10 days of the completion of the inquiry. The recommendations have to be implemented by the employer within 60 days. And if any person who is aggrieved by the order, by the report, can file an appeal within 90 days of such recommendation. Now, confidentiality. The parties have to keep confidentiality, which is every person involved in investigation is expected to keep such information confidential. The identity of such parties shall not be made known to the public, press, and media. The company shall take disciplinary action against a person who, without authorization, reveals such information. So there has to be strict confidentiality because these matters of sexual harassment, they are really sensitive. They can be sensitive as far as the girl is concerned and also may hamper the reputation of the respondent, the guy. So, as I said, every case has to be kept confidential, not only by the parties concerned, the employer, as well as the internal complaint committee. Now, what can be the action for false and malicious complaint? Not every complaint of sexual harassment means that, yes, there has been sexual harassment. The ICC has to go into each and every point and then come to a conclusion. So this ICC has a huge power in its hands. It is nothing else but a court which is internally formed with one external member. So it has to be an autonomous body. It cannot look at each and every case, just on the basis of the complaint made. So it has to go into the details of each and every case. If there is a false complaint, that should be avoided. The anti-sexual harassment policy has been designed to promote a better working environment. Some employees may tend to misuse the policy out of malice towards the other person, or file a false complaint, or produce false or misleading documents, or witnesses may give false evidence, misleading documents. The law does not take this very lightly. The ICC also in its report has to take some action against these witnesses concerned. Then in case the company or the managing director, as the case may be, may take action as per the policy or the service rules applicable to the false evidence, or in a manner which is prescribed as far as the rules are concerned. Then there is a case, Hindu Singh versus Union of India. The courts have held that just because a party is unable to give any proofs with the complaint, it does not mean that that complaint is false, and malicious, case for malicious action cannot be instigated against that complainant. Just because she did not have any proof attached to her documents, or she did not have any proof, that does not mean that it is a false complaint. And as a false complaint under the Act should be avoided. Now, with this, I take you through various judgments as to what the Supreme Court and the various high courts have held time and again. Now, the Delhi High Court in Dinesh Mishra versus Trilochan Mohapatra has held that the transfer of the respondent to, just a minute. Now, what the court has held is the transfer of the respondent to any other workplace of the employer based upon the recommendations of the internal committee pending the inquiry. As I said, what are the interim measures? They can ask for transfer of the respondent also. In such case, the court has held that transfer pending inquiry, so as to bring some sort of immediate relief to the aggrieved person, is absolutely valid. There was some kind of sexual harassment complaint which was made and by the aggrieved woman, and she requested by an interim measure that I do not want to see the person in front of my eyes. So she requested the internal committee to transfer the respondent. The internal committee transferred the respondent, and Delhi High Court held that such transfer of the respondent pending the inquiry is valid. Then there was another case of the Karnataka High Court in which a professor, there was a report which was given against the professor, the inquiry report. So the High Court set aside the inquiry report against the professor, and then also directed the authorities to initiate action against the director as well as the members of the internal committee for violation of the provisions of the Sexual Harassment Act. As I said, the law will, just because a report is given and an ICC is constituted, it does not mean that your work is over. You have to follow the procedures which are prescribed. If that is not done, the courts, later on, if at all a party goes in appeal, the courts are going to minutely look at each and every action of the committee also. And in this particular case of the Karnataka High Court, the court came to a conclusion that there is no sexual harassment involved, and it could see some sort of gray area. So there was action which was initiated against the director as well as the members of the ICC. Then in the next case, the Delhi High Court, in the case of Rashi versus Union of India, held that filing of a false sexual harassment complaint, filing a false sexual harassment allegation under the Act is an afterthought after getting dismissed, will not be tolerated. What in this particular case, the aggrieved person, she filed a complaint, and the court will, as I said, look in the totalitarian circumstances. So she was dismissed, and then as an afterthought, she filed a complaint for sexual harassment. The court looked at it minutely and then held that this will not be allowed. This is a pure afterthought which the female has done, which she is not allowed to do. So all these cases also, despite a law being there in favor of a woman, but does not mean that just because a woman comes up with a case that she's actually sexually harassed. The courts look at everything and then they pass an order. Similarly, the ICC has to look at everything and then pass an order. Then the Kerala High Court, also in another case of 2019, held that an internal committee and the principal of the college looking into sexual harassment allegations against a student must take a lenient view, keeping in mind the age and the future of the student and the provisions of the POSH Act. There is no straitjacket formula for dealing with the complaints under the POSH. So you have to look at the circumstances and the person who is the respondent. Everything should be looked at and then an order should be passed. So over here, the Kerala High Court said that a lenient view has to be kept because look at the age of the respondent and the future. And because that person, the respondent, is a student, so strict action should not be taken. So this was the view of the Kerala High Court. Then the Supreme Court also held in this Tandel case that departmental proceedings and proceedings in a criminal court are completely different, as the purpose, the standard of proof and the approach are completely different. The initiation of the process in a departmental proceedings in case of an alleged charges of sexual harassment charges cannot be said to be amounting to contempt of court, even if the criminal proceedings were pending before a judicial forum. The very first question which many people ask is, if we go to the ICC, can we go to the police and file another complaint? Definitely that can be done. These two, now the proceedings under POSH are departmental proceedings. They are independent of proceedings under the criminal court. They're two different with a different purpose. The standard of proof also is different and the approach is different. So because there is a departmental proceedings that is under the POSH Act, under POSH, it cannot be said that it is contempt of the criminal court. That criminal case is going on as well as departmental proceedings, because people consider criminal court to be probably superior. In such cases, the court has held that there is no contempt of court if parallel both the proceedings are going on. So you can definitely approach ICC committee under POSH Act if there has been sexual harassment of workplace, as well as you can file a criminal complaint before the police, and then the procedures of criminal law will take its route. That is perfectly valid. The interim order recently was passed by the Delhi High Court in Rubani case, in which it ordered the employer to pay lump sum amount of 1,20,000 to the petitioner as she was terminated from the company after raising complaints of sexual harassment. As earlier ma'am had said, that when a company receives a complaint of sexual harassment, what it first does is it tells both of the parties to resign. We don't want you as a part of the company. That should not be done. Every complaint should be looked at properly. And in this particular case, when the petitioner, the aggrieved person, was asked to resign from the company, she went to the court. The court held that the company has to pay a lump sum amount of 1,20,000 to the petitioner because she was terminated. In another case only like this, wherein the aggrieved person was asked to terminate after she made a complaint, the court held that the company has to pay damages to the tune of 26 lakhs, 25 or 26 lakhs that the company had to pay to the aggrieved person. So that should not be allowed to be done. So as soon as a complaint is given to the committee or to the employer, in that case, the first reaction is not termination. She should not be terminated. Then the Delhi High Court in this Viragshah case held that mere shouting in anger at a woman cannot come under the definition of sexual harassment. So there is no straitjacket formula. The definition of sexual harassment under Section 2 of the Act is inclusive. So just because of woman, she made a complaint, as in this particular case, that the respondent shouted at me, and so she filed a case for sexual harassment. In this case, the court held that mere shouting in anger at a woman will definitely not constitute sexual harassment. In another judgment of the Goa High Court, the High Court quashed the inquiry report of the internal committee and directed the institute to comply with their regulations and constitute an internal complaints committee in compliance with the regulations. So Here an internal committee was constituted, but they did not, in this particular case, they did not have an external member, which was mandated as per law. So the inquiry report which was given by the internal committee was quashed, and the court first held that first you comply with the provisions, first you have an internal committee as per the law, and then that internal committee is going to give a report. So the procedures which are written down have to be followed. Then there is another case of Mrs. Bagga and others versus local committee complaint, district Indore, which is taken up by the MP High Court. Now, in this particular case, I will be dealing with the facts also. The complainant, who was a senior marketing manager at a hospital, she was sexually harassed by her immediate senior. Now, constituting an ICC is a mandatory requirement under the POSH Act, which the respondent hospital failed to do. The hospital has failed to address the humiliation and harassment faced by the lady complainant. Also, when the complainant tried to raise her voice by bringing the issue to the notice of the managing director of the hospital, her case was not acknowledged and she was terminated from her services. Since there was no ICC register, she registered her complaint with the Women Welfare Department of Women and Child Development Ministry. The Local Complaints Committee, the LCC, which is also constituted under the Act. Now, this LCC is appointed by the government. So that LCC recorded the statement of the complainant and subsequently passed an order against the hospital. The hospital challenged the said order before the High Court. High Court not only dismissed the hospital's appeal, but also slapped a penalty of 50,000 on the hospital for not having an internal complaints committee, and also directed the hospital to pay a compensation of 25 lakhs to the complainant for failing to address her complaint of sexual harassment. Now, the court looked at it very minutely. The law says that if you don't have an ICC, then 50,000 is the penalty for the first time, and the compensation was 25 lakhs because the hospital failed to address her grievances, and then the hospital terminated her services. So to the tune of 25 lakhs, a compensation was paid to the aggrieved person. Now, as far as these are the judgments under the POSH Act. Now, there are certain mandatory compliances which have to be done by every organization. As per the office order issued by the government of Maharashtra, every government, non-governmental organization or private undertaking, society, enterprise, trust, manufacturer, supplier, industrial health services, financial unit, service provider, hospital, nursery, they are required to submit the details of their IC in the prescribed format to the district women and child development officer. That has to be compulsorily done. An order has been passed by the government of Maharashtra, and there is a prescribed format. So I request each one of you that such order be complied with, as well as you can request all your clients also that this should be done, and ICC must be constituted if you have more than 10 employees in your organization. It is mandatory for the ICC to prepare in each calendar year an annual report and submit it to the employer. Every ICC has to submit a report to the employer. The report should contain the following: number of complaints of sexual harassment received in the year, number of complaints disposed of during the year, number of cases pending for more than 90 days, the nature of action taken by the employer, and the number of workshops or awareness programs conducted against sexual harassment. So the ICC has to give a report of everything to the employer in each calendar year. That is nothing but an annual report. Then, as there was an amendment in the Ministry of Corporate Affairs through a notification of 2018, amended the company rules 2014 and mandated every ICC to submit an annual report to the employer and district officer. By this amendment, it is now mandatory to disclose that the company has implemented the provisions of the Sexual Harassment Act. This report has to be filed along with the annual returns to the registrar of companies. So these three slides which I took you to, these are the recent orders, and every organization as well as a company has to comply with these orders, as well as have an ICC under the Act. So with this, These are the things that I probably could help you with as far as POSH is concerned. Take over your entire POSH department or assist you in forming an ICC if you have not done it. Become an external member. Form guidelines on the working, assisting in the entire process of the inquiry, assisting in drafting complaints, drafting inquiry reports. If you want me to assist the employer, forming of POSH policy for your organization, holding orientation programs, conducting seminars for the employees and the ICC, creating general awareness under the POSH Act and education under the Act, training of the ICC members, and complying with the legal formalities. So with this, I hope I have taken you or brushed you through the entire Act. If you have any questions that you would want to ask, you can ask me in the chat box, or you can directly message me with anything. I will be there to help you out. Over to you, Virag. Virag? Do you all have any questions? Virag? If you all have any questions, you all can put it in the chat box and I will be happy to address you. I have, I think, 5 odd minutes that I can help you with this. Or if you want any kind of information, you can let me know.
Surbhi, can we take few questions?
Yeah, sure, because I did not get any of the questions here. You can let me know.
I think I have given the right now. You can see in the question tab.
What if the organization, I don't know why I'm not able to. Just 1 minute, hold on. I will address all your questions. What if the organization is not able to find external member for ICC? As I said, ICC's external member is mandatory. If there is no external member, then any report which is given by the ICC is set aside by the courts, and you have to have an external member as per law. There is no second way to that. You have to find it. I don't know why I cannot access the questions. As you have explained, according to the Act, an ICC has to be set up at every administrative unit and office. How do I zoom this?
Undock from control.
Join tools, make another attendee. Yeah, got it. Who will be the presiding officer if the company does not have any female this thing? The Company Act states that, the POSH Act states that the senior most female person has to be there. Whoever is there, the most senior most level, that female has to be the presiding officer. If not, then I think you should employ a female and who would be there as a presiding officer in such a case. Who are deemed external member? Someone who's not on your payroll or who you have not appointed is an external member. So that external member also should be there. What should be the minimum number of employees? As I said, there have to be 4, but 3 people have to be present as far as a complaint during the inquiry process is concerned. What is the penalty? Penalty is that penalty for not having an committee, 50,000 if the court comes to conclusion, and then later on it may also revoke the license. So it is mandatory for every company to have an ICC. What if there are only 3 to 4? Now, irrespective of the number of female employees, this act is applicable on everyone, but only an aggrieved person, a female, can file a complaint. So irrespective of number of employees, if there is one employee also a female employee, or there are 100 female employees, or 3 to 4, you still have to comply with the provisions of this act. What if the organization is not able to find external member for ICC? I do not know why the organization will not be able to find. I mean, that probably gives me work. So yeah, there is no way out. You have to have an external member. Thanks for recommending and understanding men's empathy as well. Of course, not every case is in favor of the female. How ICC to be formed where the total employee is less than? I'm sorry, you should tell me less than what, because there have to be more than 10 members, 10 or more members, employees should be there in a company, and then you can have an ICC in that company or organization. Is it mandatory if all the employees are men presently? Yeah, it is mandatory, because even if a woman comes to your organization for any kind of work, so does not mean that she's your employee only. So if she just visits your workplace, that also comes under the ambit of sexual harassment at workplace, and an ICC is mandatory. Previously, there were women employees in the organization. Irrespective of women or men, at least one woman should be there on your payroll who can be a senior most employee, and an ICC is mandatory. The act does not state 10 female employees or more. It states 10 employees. If you have 10 employees or more, ICC is mandatory. Period. That's it. Not at all drafted POSH policy. I did not get your question. Nitin Tiwari. No voice has left. Ma'am, what is the slur? Slur is kind of an abuse. Is there any special provision for university? Yes, university also there is, there is a special provision, and university also has to have an ICC. You can let me know. I will give you the, I can email you all the special provisions as far as the university is concerned. This is just the general overview of the entire act which I could give you. Then, is there a liability of the employer if some male employee has done something wrong? There is no liability if the employer complies with all the provisions of law, which I have tried to tell you. Then there is no liability on the employer. Is reporting the requirements mandatory only to listed companies? No, to all companies. Is it necessary to have the policy and the ICC if there is no woman employee in the employment? Yes, it is necessary. More than 10 employees mandates you to have an ICC. Which question? Who can be the presiding officer if the company does not have any female employees? There is no way out. A senior most female employee has to be the presiding officer. Who are deemed external members? Where can be appealed against the decision of the ICC? Under the Industrial Disputes Act, the appeal can be filed. So it is basically to a labor court. Any authority which is prescribed under the Industrial Disputes Act, that is the appellate authority to the ICC. What should be the minimum number of employees to form an ICC? Dealt with this question. 4 and 3 members have to be present for an inquiry. What is penalty if the company is not having committee? Nitin Tiwari, I think I've already dealt with this. I'm sorry. How ICC is to be formed at the how ICC is to be formed where the total employee is less than, I don't know. The ICC mandatory if employees are men presently. Previously, there were women employees in the organization. I dealt with this question. have asked above, as a standard practice, ICC have been constituted at head office, and it's not possible to constitute ICC in each and every branch in case there are multiple number of branches. Is the standard practice followed where benchmarking with other similar or non-similar industries? Now, the Act itself states that if you have a separate branch, a separate ICC has to be constituted. I cannot give you any opinion which is against the law, so I'm sorry, but for every branch, a separate ICC has to be constituted. Ma'am, if a former employee can file a complaint against POSH, what timelines for that? If the employee has already left the organization, then how can she file a complaint for POSH? It depends on the facts. So what timelines? If it falls under the ambit of what I have told you, then the timelines also is what I have told you, 3 months of the last incidents. So the same timelines have to be followed. Is the reporting requirements mandatory only in district? I have answered this. Is it necessary to have policy and ICC if there is no woman employee? I have answered this. Is it necessary to record the proceedings of the inquiry? No, it is not necessary to record the proceedings. If you wish to or you want to, you may have that. There is no law mandating that, but your inquiry report is going to have all the details of the date and the nature of the proceedings which have taken place or the inquiry. Is a committee required to be formed even if the entity is having one woman as employee? Yes. How can we proceed with the composition of the committee? Well, I have given you a general outline as to what should be done by the employer. If you still have any questions, you can connect with me and I will be willing to answer you as to how you all can proceed for the composition of the committee. And no interim order, an interim order dated 10th Feb 2020. Why she has terminated, not clear. I do not know what you are talking about. So please can you ask me in detail, Ranjana, and I will answer you. If we, as a professional lawyer, provide certain retainer services to limited company, can we get appointed on ICC? Well, you can get appointed, but you cannot become an external member. Kavita Malani, I think I have answered you on this, that yes, again, you can be appointed or nominated, but you cannot be the external member. If the number of employees are less than 10, ICC is not required. No, it is not required if the number of employees are less than 10. If no female employee is there, can company refer the matter to LCC formed in every district? In that case, ICC formation can be skipped. Well, as I said that even if the LCC gives an order, we don't know how the court will look at it. So better to have a ICC in every branch office. Even if there is no female employee, you can have a female employee on your payroll and make her the senior most member at that time. ICC is to be formed in case of 10 or more employees. What are the compliances to be done in case of less than 10 employees? No ICC to be there in case of less than 10 employees. I understand that policy is to be adopted by every organization company. In case of limited companies, do we have to adopt the policy by passing board resolution even when the number of employees are less than 10? No, if the number of employees are less than 10, then you need not have an internal committee. Definitely you can have a policy to prevent sexual harassment, but there is this act or the formation of an ICC need not be done. Hi, Yashpreet. Then good afternoon, Viragshah and all. Employee of group companies can be deemed as external members. Well, I will advise not. I will advise not, because then by the end of it, it can be seen, as I said, you go into the root of the matter that ICC has to be an autonomous body. If some sort of relation also is shown by the person who's challenging the order, then the entire inquiry procedure is going to go down the drain. In such situation, I will advise that the employee of the group companies should not be made as external members. How to constitute ICC? Can't hear. Can independent director be a part of the committee and consider as external member? And if that is female, no, that cannot be done. External. The role of external member has to be independent. Okay, she cannot be, or a part of that organization in the remotest way manner also possible. So an independent director, if she's a director of that company, she should not be a part of the committee as an external member. Definitely he or she can be a member of the committee, but not an external member. Can professional attached to a company be an external member? A professional in the sense, if you give legal services also, probably if you what do you say, not on the payroll of the company, then yes, you can. Can independent director be a part of the committee and consider as external member? And if it is female, I've answered this. Can an appeal be made? Yes. As you have explained, now this is Ranjana Ahuja's question. As you have explained, according to the Act, an ICC has to be set up at very administrative unit and office in one of our client at Internal Complaints Committee to investigate any complaint received under the Act was not constituted at the branch level. Nomination of the members are yet to be formed. Client has replied it has to be constituted at head office and it's not possible in each and every branch in case there are multiple number of branches. Is that standard practice followed when benchmarking with other similar or non-similar industries? No. In fact, leave what is followed in the practice in the market, but the Act itself states, you can send this to your client also, you can go through the provisions of the Act, and that itself states that every branch has to have a separate ICC. So I don't think you can do away with this mandatory provision of law. No, it does not go to the High Court and appeal against the ICC. An appeal against ICC goes to the court which is set up under the Industrial Disputes Act. Aggrieved woman is compensated by respondent or employer. Of course, the respondent is going to compensate the aggrieved woman. There is no way why the employer is going to compensate. But if the employer has not set up an ICC, in such a case, then the fine that has to be paid by the employer, not the respondent. The respondent is only going to pay the sum to the aggrieved woman for compensation, but the employer is going to be paying if he has not constituted the ICC. Okay. I think, are these questions done? Have I answered all of them?
Yes, yes. I think all the questions are answered now. Thank you so much for a wonderful session.
No problem.
We have answered all the questions as well. You are wonderful as last time also. Would like to request all to have a vote for our poll. We have just launched. We'll be there for 15-20 seconds more. Meanwhile, would like to request to come on screen. Nishi is there. Nishi, are you there?
I don't think she's there. I don't know.
We got wonderful feedback as well in our poll. More than 90% responses.
Thank you. I hope it was helpful so as to create some sort of awareness. Probably you as chartered accountants will be able to host such kind of seminars for your client companies. Then please go ahead and do that. And
yes,
all the best.
Just quick poll is going on. So we'll share result as well. Sure. We required few more votes to close the poll. So all are requested to vote immediately. We got a great response, although I'm not sure because our target audience are chartered accountant, but still we got a wonderful feedback. So result are here, you can see very well. more than almost 100% extremely satisfied and moderately satisfied. And also for this also, a few people are asking for presentation as well. So kindly share that as well.
I will not be able to share the presentation with you. Of course, after this on WhatsApp, I may be able to share with you a small write-up on this. So, yeah.
Okay. Not an issue. So thank you for wonderful knowledge sharing session on Sunday evening. So with this, we will conclude. We are logging off, and be in touch with us for more such webinars. Thank you all. Thank you all participants. And thank you, Surbhi. Thank you so much.
Thank you all for such a patient listening. Thank you.
Thank you.